Good afternoon. I would like to welcome all of you to the CONECT two-day program on forced labor and the implementation of the Uyghur Forced Labor Prevention Act. I'm Paula Connelly, the current president of CONECT and an attorney with Sandler, Travis, and Rosenberg, heading up the Boston area office. Although the Russia-Ukraine situation is currently dominating the news, the issue of forced labor and the treatment of the Uyghurs continues to be a priority area for the US government, particularly within CBP. As many of you know, the UFLPA was recently implemented and many companies are concerned about the potential implications for importers. In addition to the UFLPA, which focuses primarily on China and products made with forced labor in China, it is important for companies to understand that forced labor is a global issue and that there are other countries in which forced labor occurs. Today's program will focus on the statutory and regulatory aspects of forced labor. Our speakers will discuss the UFLPA, but in addition, provide an overview of the process in which CBP determines that goods may be made with forced labor, the issuance of withhold release orders, and detentions of shipments for the same. In addition, we will include an overview of the current status of withhold release orders. Finally, we will provide recommendations on responding to detention notices and substantiating that goods were not made with forced labor. Tomorrow's program will be more of a roundtable discussion with our panelists. We will discuss best practices for mapping your supply chain, along with a case study of several examples of products and the issues that can arise when trying to identify your full supply chain. For the session today, please send your questions through the chat box and I will address them with each speaker when they are done with their presentation. And with that, I would like to introduce our panelists for the program. Therese Randazzo is the director of the Forced Labor Division in U.S. Customs and Border Protection's Office of Trade. She manages the investigation of allegations of forced labor in U.S. supply chains, recommends withhold release orders and findings to prevent importation of goods produced with forced labor. And she also refers cases for potential criminal investigation or civil penalties. She also recommends modification of revocation of WROs and findings based on petitions submitted by interested parties. Therese has more than 30 years of experience with CBP and its predecessor agency, the U.S. Customs Service. Therese received a Bachelor of Science, Business Administration from the University of New Orleans. She's a graduate of the U.S. Office of Personnel Management's Executive Potential Program in the Department of Defense's Strategic Studies Program. The World Customs Organization selected Ms. Randazzo for accreditation as a Customs Modernization Advisor in 2014. Amanda Levitt is a member with Sandler, Travis, and Rosenberg, resident in the New York office. Her practice is focused on international trade and customs law, particularly relating to classification, marking, country of origin issues. She's advised clients on a broad range of matters, including customs audits, forced labor issues, Section 232 and 301 tariff mitigation, penalties, and first sale valuation. Amanda is a member of the firm's forced labor group and has handled a number of forced labor cases. She holds a JD from Fordham University School of Law and a BS from Connelly University. David Murphy is a partner in the law firm of GDLSK. David has more than 25 years experience in handling complex cross-border issues with respect to customs and trade, including US import and export control, international sanction programs, drawback and special duty programs. He represents clients before US Customs and Border Protection, Office of Foreign Assets Control, Department of Commerce, Bureau of Industry and Security. David is also a licensed US Customs broker, certified customs specialist, and an accredited zone specialist through the National Association of Foreign Trade Zones. Finally, Erika Vidal-Faulkenberry leads the global trade compliance for Biogen, a leader in biotechnology. She is responsible for designing, setting, and implementing strategic direction, policy, and end-to-end capabilities, such as scalability, human capital, processes, and systems. Erika has over 17 years of experience in global trade and international supply chain, working in a variety of sectors from energy, consumer packaging goods, biotechnology, and business consulting. Additionally, she is an active member at international trade associations such as the American Association of Exporters and Importers, National Association of Manufacturing, and the PHRMA. Erika holds a Bachelor of Science in International Trade from Tech de Monterey, a Master of Arts in Applied Economics from Clemson University, and a Master of Arts in Supply Chain Management from Penn State. She is also a licensed customs broker. And also, Erika was recently reappointed as a COEC member from the 15th COEC term, where she served as the co-chair of the Trusted Trader and the Forced Labor Working Group. So you can see we've got a wealth of knowledge and experience here in our program today and tomorrow. And I'm looking forward to hearing all of our speakers. Again, if you have questions, please just send them through the chat box, and I will answer them again when the presenters are done. And with that, I'm going to turn this over to Ms. Randazzo for her starting comments.
Good afternoon, everyone, and thank you to CONECT for the opportunity to once again speak to your membership. It's always a pleasure to be with you all. I understand that there's a great deal of interest in the Uyghur Forced Labor Prevention Act. Unfortunately, there's very little that I can actually share on that today because there's a current public comment period open in an upcoming public hearing. But the law was, President Biden signed the law, signed the Uyghur Forced Labor Prevention Act, or the UFLPA, as some of us like to call it, because if you're at CBP and you have anything that has 5 letters, you must come up with an actual pronunciation. You can't just say the letters. So you have to make it into a word. So we call it the UFLPA. So it was signed into law on December 23rd of 2021 and goes into effect 180 days from that date, which is June 22nd, June 21st of 2022. The Department of Homeland Security, CBP's parent agency, is the chair of the Forced Labor Enforcement Task Force, which is an interagency task force that was created under the USMCA. The UFLPA tasked the FLETF, as we call them, with developing an enforcement strategy to support 307 enforcement regarding goods that are produced with forced labor in China. So DHS has issued the Federal Register notice on January 24th, soliciting public comment for input related to that strategy. That will be followed by a public hearing on April 8th. And unfortunately, until we get to the end of that process, I'm not able to discuss any details regarding potential implementation of the UFLPA. So with that, I will redirect my comments towards current enforcement of WROs and findings, and also talk a bit about some of the CBP thoughts on admissibility packages, which is the documentation that importers submit to CBP when they are seeking release of goods that are held either under a WRO or a finding, and then look at some of the resources and CBP thoughts on due diligence. So with the UFLPA, when it goes into effect, it does not, we're still going to see WROs and findings remaining in, a number of them remaining in place. So this is still very important information to have and to be aware of. So turning to the enforcement process, US law prohibits the importation of goods made in whole or in part with forced labor in a foreign country. And CBP enforces that statute. So that process works like this. We receive either an allegation of forced labor from, it can be virtually from anybody, usually from civil society organizations and non-governmental organizations, but it can come from virtually anyone: witnesses, victims, the media, private sector, individuals, whatever. Or we can also self-initiate an investigation. So when we receive an allegation, we self-initiate an investigation into forced labor in the US supply chain. We are looking to determine whether or not one or more of the International Labor Organization's 11 indicators of forced labor is present in the production of goods that are in the production of goods. So I'm not going to get into the details on the International Labor Organization's 11 indicators in the interest of time, but there is a brochure on the ILO's website that describes these indicators and gives examples of what they are. If you're looking at assessing a supply chain risk and determining whether forced labor exists, I would strongly encourage looking at those indicators and being familiar with them, because those are the same indicators that CBP is looking for. Where we have information that reasonably indicates that one or more of the ILO indicators is present in the production of a good, and this can be anything from raw materials to final products that are shipped to the United States, then we would issue a withhold release order. The withhold release order instructs our ports of entry to detain goods that fall within the scope of the order. Importers then have 3 months from the date of importation to either export the goods or contest the goods. You can also abandon them, but in general, we're focused on exportation or contesting the detention. If you're going to contest, you have to demonstrate that the goods are not subject to the WRO or that they were not made with forced labor. And I'll talk a little bit more about the admissibility packages and the review process in a couple of minutes. If we get to the end of the 3-month period and the importer has not exported the goods, or the information that they have provided to CBP is insufficient, then the goods will be, then CBP excludes the goods from entry into the US, and the importer must export the goods unless they protest the exclusion. A little thing that's not really clear necessarily in the regulations, but that I do want to note is that if we get to the end of that 3-month period and CBP is still reviewing documentation that you submitted to try to establish admissibility, to establish that the goods are either not subject to the WRO or not made with forced labor, CBP will continue to review that documentation and make a decision. However, the end of that period does trigger the importer's right to protest. The goods are deemed excluded at the end of the 3 months. And you can go ahead and proceed to protest then if you wish, or you can wait until CBP completes the admissibility review and renders this decision to release or exclude the goods. If we exclude at that point, you can still go ahead and file a protest at that point if you wish. And I'm going to wrap up there on that topic because I know Amanda is going to talk a lot more about that. The finding process is very similar to the WRO process in the sense that the process CBP goes through to issue a finding is the same as we go through for issuing a withhold release order in terms of conducting an investigation and determining the presence of one or more of the ILO indicators. However, if we're going to issue a finding, we have to have conclusive evidence that forced labor is occurring. So it's a higher evidentiary standard, and those will actually be published in the Federal Register and the Customs Bulletin, and they require the approval of the Secretary of Homeland Security. There's also a key difference after a finding is put in place, because goods that are subject to a finding, CBP will seize those goods and initiate forfeiture proceedings if the importer is not able to establish that they are admissible into the US. There is no exportation of goods allowed under a finding. I can say that findings at this point in time are much less frequent than WROs. In 2021, we issued the first finding in almost 25 years, so they're a lot less common, but they do exist. And we have several active findings now, which David's going to talk about later. So with regard to recent WROs and findings, things that are say from the start of our new fiscal year, which began on October 1, the pace of enforcement has continued quite briskly in terms of enforcement of Section 307. We have issued 5 WROs and 2 findings so far this fiscal year. The WROs are on tomatoes produced by Agropecuarios Tom, and I'm sure I did not pronounce that well, and Horticola Tom on tomatoes produced by these 2 Mexican farms. The remaining 4 WROs that were issued between October and January are all on Malaysian glove manufacturers. Manufacturers of disposable gloves, and they include withhold release orders on Supermax, Smart Glove, Brightway, and YTY. And these WROs include the subsidiaries and joint ventures of these companies. The 2 findings published so far this year were published on the 28th of January. The first of them is on palm oil, which is produced by the Sime Darby plantation in Malaysia, and it applies to palm oil produced in Malaysia by Sime Darby and its subsidiaries and downstream products that contain that palm oil as well. And the second finding is on seafood that is harvested by the Vanuatu flagged vessel, the Dawang. Turning to admissibility packages, because this I know is something of tremendous interest to a lot of people because of the amount of work that can be required to assemble the appropriate documentation and the challenges sometimes of getting that. So if you look at the customs regulations, 19 CFR 1243 requires that a certificate of origin requires a certificate of origin. This is not a standard certificate of origin. It's a certificate of origin whose format is specified in that section of the regulations, and it must be signed by the final seller in each country for products for each country in the supply chain. So if you have a supply chain where you have raw materials produced in one country, and then it goes through various production steps, and then there's a final shipment to the United States, you'll need multiple certificates of origin. It also requires a statement by the importer that details their efforts to ensure that goods are not made with forced labor. Occasionally we get those things and really little else. I can tell you that is not going to get the release of the goods. You have to support that statement with documentation. So the sorts of things that CBP is looking at to be in that admissibility package, in that documentation that is submitted to support the contesting of a detention and the request that CBP release the goods. We're looking for generally this is documentation that is kept in the ordinary course of business. It's not things you have to go out and produce or create, but it's ordinary business records, such as the full records of transactions and the supply chain documentation that would show all the parties that are involved in the production and exportation of the good to the United States and the origin of the materials going back to the suspected source of forced labor. So it's you need to, so if, for example, if we have, you take the WRO on cotton out of the Xinjiang Uyghur Autonomous Region in China, that documentation needs to show the origin of the cotton back to the bale, and then onwards through the supply chain. And Amanda's going to talk a lot more about specifically what types of documentation should be included in the packages. As I indicated, the exact documents that need to be submitted depend on the type of goods and on the complexity of the supply chain. As you can imagine, I'm sure if you haven't been through this process already, the documentation that's required to show admissibility, to show that goods are not subject to a withhold release order is significantly less if we're talking about a tier 1 supplier versus if we're talking about a raw material or a minimally processed product that's then incorporated into other products that eventually are and finally into an end product that is shipped to the United States. The production of downstream products, the WRO materials, agricultural products, and the like does apply to downstream products that are produced in third countries using those imports. So obviously it becomes much more complicated the further back in the supply chain that the forced labor is occurring. The detention notices that CBP issues for WROs contain a general description of the type of documentation to submit, and they are in many cases specific to a certain WRO. So the detention notice for the Hoshan WRO would be different from the notice that would be issued, say, for gloves out of Malaysia. Because the tiers are different and the products are very different. The imported product in the Hoshan case is generally a more of an end product, such as solar modules. Certainly, it's not the silicon metal is generally not the product that's being imported. So the detention notice is what will assist you in identifying the types of documentation to submit. I would also suggest that if you're providing documentation, particularly for a complex supply chain or a long, or tracing a long ways back in the supply chain, you're going back several tiers, that you include some sort of roadmap for CBP, something to help us navigate through the documents and to understand the production of that product and the importation of that product. So to tell that story as to how that product was produced and came to be, where it was sourced from, who was the source, and how it got to the United States. These types of things, while not absolutely required, will help speed up the process, because that way CBP knows how to follow the documents, as opposed to having to try to put, assemble them in the correct order and figure out how they link together. If you have source documentation that is not in English, it's very helpful to have that documentation translated. If it is not translated, it is very difficult generally for CBP then to review that documentation and to assess its utility in establishing the admissibility of the goods. So I would encourage English translations of documents, or certainly of the relevant portions of documents. In wrapping this up, I would say the determinations, you have to keep in mind that they're very fact specific, and CBP considers them on a case-by-case basis. And so what you submit needs to be, is dependent upon the particular product that's being imported and that particular supply chain. We are endeavoring to, where we have supply chains that are where we have essentially the same supply chain of goods, be it repeat shipments of goods in the same supply chain, presenting that information in a similar format, and alerting us to that is very helpful. That does also help to speed up the review. Turning to some sorts of reference materials for risk assessment and due diligence that you might find helpful. I think it is important for importers to look at things that may indicate risk in their supply chains. So there's a lot of information on the forced labor page on cbp.gov, and we are continually updating that information. So that includes links to the ILO's indicators that I mentioned earlier. It includes links to all existing WROs and findings. There are sheets on there, fact sheets or slick sheets on there that provide links to resources on due diligence. And this includes links to US government publications and resources, either produced by CBP, produced by the Department of Labor, produced by the Department of State, as well as the OECD, the Organization for Economic Cooperation and Development. They have general due diligence guidance, as well as some sector-specific guidance. The website also includes a general set of FAQs, which we are working to update, and it also has specific FAQs related to the Xinjiang Regional WRO and the Hoshan WRO, because we've gotten so many questions from importers regarding those two WROs. There will be some additional information coming out soon related to due diligence and FAQs. So keep your eyes open for that. And then finally, also on cbp.gov, you'll find links to the Xinjiang business advisories that were issued by the Department of Homeland Security in July of 2020, and then an updated advisory that was issued in July of 2021. If you are sourcing goods from China, and in particular from the Xinjiang region, now is a great time to take a look at those, especially in light of upcoming the upcoming UFLPA. There's also a relatively new tool out there that was released by the Department of State called the Responsible Sourcing Tool. This was the state worked with Verite and a couple of other organizations to develop this tool and to provide a resource for not only companies, but also for federal contractors, for federal acquisition personnel, as well as for investors, consumers, and others who are interested in forced labor and ridding for supply chains of forced labor. To wrap up, I'm going to turn a little bit more about, just want to share a few insights that CBP sees with a lot of due diligence and programs and social compliance programs. First, I would say it's important to know the supply chain from the origin of raw materials to the goods that are imported in the United States. A lot of times what we see with compliance, social compliance programs is that they only look at the first, maybe second tier of the supply chain. And so a lot of importers have been caught off guard by WROs that are on raw materials or minimally processed products, where they have not looked into the supply chain going back that far. They don't really know what the supply chain is. They don't know if risk existed there that they could have addressed. And now they find the product subject to WROs or even findings. So know the whole supply chain, I would say, is important. When you're actually trying to get this information from suppliers, in many cases, particularly in China, where you have the anti-sanctions law, some suppliers are reluctant, from what we understand, to provide information. There might be a value in, instead of asking, where the goods came from or whether they were made from forced labor or whether they're from the Xinjiang, if you could, maybe better just ask for the identification of the suppliers and just say you want to know where the goods are sourced from. You want to know the source of those goods. Rather than saying, do you use a supplier that's in the Xinjiang, or are these goods made with forced labor? Everybody's going to say they weren't made with forced labor if they answer the question at all. So we've gotten feedback from several entities that say this approach works better. So I just wanted to share that with you. You should maintain awareness of the risks that are for forced labor in the supply chain and take steps to minimize that risk. I mean, get in front of it before we issue a withhold release order. So look at the U.S. government information I mentioned. There's also many civil society organizations and non-governmental organizations that are working in the forced labor and human trafficking space. They publish, some of them do publish reports. So it's a good day. So you might want to do some searches for some of those. There are media reports by investigative journalists and others that may point you to risk in your supply chain. If you're doing site visits, that can be helpful. Generally, we find that those are only usually to the first tier supplier and not far enough back. If you're using other parties to do site visits, we do have some thoughts on that. And I would suggest that if you're going to implement a due diligence program, and some of the other speakers will cover this in more depth. That it's important not only to have that plan in place on paper, but you also need to make sure it's actually been implemented and monitored. That plan is compliance program. Here's our social compliance program, but there's no verification that it's being implemented, no monitoring to ensure that suppliers are adhering to it, no monitoring to even ensure that your own people are adhering to it. So there needs to be some verification of implementation to make sure that it's in fact in place and operating as you envisioned it would. We would encourage importers to work with suppliers to remediate forced labor indicators that are identified. But if you're not able to get the supplier's cooperation to do that, then as a last resort, your best bet may be to cut that supplier, or you just need to make the business decision to live with the risk. If you're looking at, if CBP is looking at audit information that says there's no forced labor, we are going to be looking for, as I mentioned, verification. We're generally looking at third-party verifications. And many social compliance audits, as I said, do not meet this standard because there's not a third party involved, and it's an auditor or an organization does the audit that is not really expert in forced labor, and so they really didn't properly assess whether there's the presence of forced labor indicators. We occasionally have seen audit reports that say there's no forced labor at this factory, and we have issued WROs after receipt of that report, because it's not, because the report is not convincing, it's not compelling, because it wasn't conducted in a way that would actually indicate that that they verified all the forced labor, that they actually, let me back up, that they actually went to the audit to the factory. They had independence while they were there, that in the sense that the audit was unannounced, and they had unrestricted access to the factory. If you have an audit where the auditor has worked with the factory and the factory controlled the site visit, they controlled what they got to see. They relied only on documents provided by the company. They only talked to workers that the company allowed them to talk to. That's not really a credible audit from our perspective, because the auditor will only see what the company wants them to see. And we have had cases where an audit report has come back and said there's no forced labor, but we have sufficient evidence to move forward to a WRO. So I will wrap up on that, because I know a number of my other panelists are going to address many of these topics in a lot more detail. I'll just leave you with one closing thought, that if you're going to continue sourcing from a high-risk supply chain, prepare in advance to get the documentation that is needed to demonstrate admissibility. It is easier, I think, to get that documentation on the front end when you're procuring products and when you're issuing purchase orders than it is to come back after the fact, a couple of months later, and then try to gather that documentation. And with that, I will wrap it up, my remarks.
Great. Thank you so much, Therese, for your wonderful comments. Very, very helpful, particularly the end there. I think that's great for people to keep in mind, that it's much more important to try to obtain that documentation up front. It does not appear that we have any questions for you, so I guess you've covered everything in great detail. So we thank you again for your time, and I'm going to now ask Erika to share her presentation, and she can give us her comments. Thank you again.
Thank you, Paula, and thank you, Therese, as well, for that great introduction and insight. So just a quick disclaimer before I share my presentation. I'm here as a trade professional. I'm not representing COAC in this presentation, nor I am representing Biogen, but certainly I feel honored and happy to participate here in this important topic and share public information that some of you might not be aware. Well, let me share my screen for sure. Related to COAC, the Customs Operations and Advisory Committee. There we go. Can you see my screen? Can anybody tell me if you can see my screen?
Yes.
Okay, thank you. Let me just go to presentation mode. Perfect. So what I thought I would do, because we have a great panels list, like Therese had said, and Amanda and David are going to go a lot of detail. I wanted to provide a specific information related to how COAC is organized and how does that link into some of the forced labor efforts related to what Therese was referring to. And I apologize because my screen keeps changing, so I'll refer back to this one. For some of you that don't know, COAC is the Customs Operations and Advisory Committee, and this is actually an advisory body that was created as part of the Trade Facilitation and Trade Enforcement Act of 2015. The specific responsibility of COAC is to advise the secretaries of the Department of Treasury and Homeland Security on specific topics related to operations and improvements related to CBP and Treasury and DHS functions. And I want to emphasize that the significance of COAC is specifically on advisory, because CBP is not obligated to take the recommendations, but it does cover that body, that advisory body, a specific input across industry in the US from importers. And I will go a bit more detail into how it is composed in the next slide. You can find the specific information about the charter of COAC and how it's created, but there has two main objectives, in addition to some specific things that in conjunction Treasury and Homeland Security might require to advise on. Those two are matters involving commercial operations of CBP, including advice on regulatory changes and policies that might be coming, capturing through different bodies of subcommittees and under their working groups, and I'm going to touch base on where does the forced labor working group is today, according to the public information available, and then bringing that back as one advisory group recommendations when they become necessary to Treasury and Homeland Security. The second main objective COAC is that those recommendations then are in a specific public meetings. By the TFTA, COAC is supposed to meet at least 4 times a year, and this tries to be done through the public meetings. These are public meetings that happen usually once a quarter. And these are open to the public, and there's a Federal Register notice when the date is available. And then certainly anybody interested can join and participate. For the last year and a half or so, they have been done remotely because of COVID, of course. So in my second slide, and I apologize again, this keeps changing slides. I just wanted to provide a general overview of what the current period membership for COAC is. These individuals, I must mention, are personal appointments that ultimately come from the Treasury and Homeland Security, and they're supposed to be a diverse representation of trade, as well as some of the industries related to that, as freight forwarders, etc. In the US. For the current period, which is a 16th period, it's a duration of 3 years, and there are 20 members, 2 co-chairs and 5 alternates. The alternates are members of COAC that do not have voting rights, but they do participate in the meetings, and certainly their expertise and input is valuable. The current co-chairs of COAC are Brian White and Kathy Wilkins. They represent separate industries as well. And there are currently 4 subcommittees on the COAC body based on those representations that I had mentioned. There is a secure trade lanes, and I'm not going to go through the names, but I believe that these slides will be available. And I have put also the links. This information is also available at CBP's side on the COAC chapter of that. There's intelligent enforcement, where I'm one of the co-leads currently. There is the next generation facilitation subcommittee, and then there is a rapid response, which usually works on asks for advice and recommendations that Treasury and Homeland Security might have in a very quick turnaround topic. The forced labor working group is part of the intelligent enforcement subcommittee. And as I had mentioned earlier, neither the working groups nor the subcommittees can submit recommendations on their own. They have to be part of all the processes that are clearly outlined by the statute of COAC, and then those come up eventually as recommendations in these public meetings, and they are published by the entire body. So linking it to the topic of today in terms of a specific forced labor, I'm not able to share any details related to the Uyghur Forced Labor Protection Act for similar reasons as Therese mentioned, and because I don't have that information regardless. But what I thought I would do is at least share with you, based on the last recommendations that were submitted by COAC and that are published, and the link is there, related to forced labor specifically to CBP and the Department of Homeland Security as a whole, as well as Treasury. In the last meeting, and this public meeting was March of last year, so it's technically 1 year to the date, there were 4 recommendations that were presented on very important topics. The first of it And you can get through all the detail of them. Of course, for sake of time, I won't be able to share all the details, but you can read them, and certainly they're available. The first of them related to intergovernment agencies collaboration, and specifically what that recommendation referred to was advising the Department of Homeland Security and other agencies to work in a multi-agency approach as it relates to forced labor and all the topics that come between them. So COACT's recommendation, as it's listed, mentions that there are multiple agencies that are involved not only in forced labor prevention, but also enforcement, whether it's Department of Homeland Security, whether it's ICE, Treasury, Department of Labor, USTR for some of the other international policies, etc. And the recommendation included not only extended of that collaboration. COACT understood that there are limitations with each agency, but there is a need that the trade wanted to highlight about standardization and across agencies collaborations, and not only through US agencies, but also through some of the international agencies that the US participates with in the efforts to prevent and eliminate forced labor, such as the US Foreign Assistance Programs Agency. So that was the first of the recommendation. The second one actually, part of the recommendation, and this is as well public information, was a white paper that COACT submitted as part of that meeting, related to expanding collaboration and continuous communication, as CBP has been doing it, but even extending that through other sectors within different industries and companies at all levels, because while everybody has the objective to eliminate and prevent certainly forced labor in the supply chains, there might be different activities and best practices that different industries and companies and sectors have implemented. So that white paper shows a collection of the input of subject matter experts, as well as the input from those representations, and it's called the Industry Collaboration White Paper, and you can access it as well. The third recommendation that was submitted in that last COACT meeting was related to measures of success, and measures of success, as it is listed in the recommendation, refers specifically of advising CBP on and continue to expand on some recommendations that the GAO report had provided in terms of how to measure success in terms of eliminating forced labor or at least minimizing it, focusing on the actual impact of that and quantifiable measures that go beyond just number of WROs, for instance. And then the last one that was presented at that COACT meeting that is captured CBP's website just relates of the advising of COACT to CBP that in the case that was in process of forced labor becoming another trade priority issue as defined by the legislation, that forced labor would be treated as such with the same guidelines as other priority trade issues, meaning that it would be very important that the extent collaboration across industries, across agencies would include world-class expertise, would include design of processes and policies and regulations that not only continue to facilitate trade while making sure that they're under compliance, but that also provide transparency, security, and predictability. So in a nutshell, that's been the latest information available in terms of the forced labor recommendations that COACT as the closest advisory group for Homeland Security and Treasury has provided. And if there comes a point where there would be recommendations related to the Uyghur Forced Labor Prevention Act, those would become available through the same process, through the public meetings and information that CBP will make public. So that is my presentation. I apologize again for this continuous rotation of the slides. I wasn't aware of that. But with that, I will pause for any questions and pass it to my next excellent panelist with Amanda. Let me
Okay,
stop
I
sharing my screen
don't-
as well, sorry.
And I don't see any questions here, Erika. So again, I think you did a great job covering your materials and in providing us with a nice overview of COAC and how the forced labor committee, and again, obviously a very important one, and we look forward to seeing more information that is publicly available, hopefully in the future. So thank you again. Amanda, I guess you are up now if you would like to share your screen and start your presentation.
Yes, absolutely. Thank you so much, Paula. And I will share my screen now. So please hold. And can everyone see my presentation?
Yes, we can.
Excellent, thank you. So as Paula noted earlier, I am Amanda Levitt. I'm a customs attorney at Sandler, Travis, and Rosenberg, and I will now supplement what my co-presenters have been discussing and walk through the overview of that process that importers should expect and considerations for importers for a company's customs compliance measures. So when the cargo arrives at the port and the entry is prepared, if customs flags that shipment, it's usually based upon a combination of the MID, the country of origin, and the tariff code used to make entry. And the officer will typically send over that cargo to an exam site for physical examination of the goods. So if the officer believes that the goods are subject to a WRO, customs will detain the goods. And comparatively, if an officer believes that the goods are subject to a finding, customs will seize the goods. And this distinction is important because the cargo is treated differently for WROs and findings. And by that, I mean under WROs, it's detained, and findings, it's seized. And customs treatment of the cargo subject to a finding is harsher because of the evidentiary standard that Ms. Randazzo mentioned before, where a finding is based on conclusive evidence of forced labor at that facility or in that region that the finding relates to, whereas the evidence supporting a WRO must be reasonable, but it need not be conclusive. So if your merchandise is detained, the officer will issue a detention notice. And fortunately, many of you may not have experienced a detention of merchandise yet, which would be an excellent scenario to be in as an importer. But if you haven't seen a detention notice yet, I included a screenshot here of a redacted detention notice so that you see what it looks like. So it's a typical form that customs will identify certain descriptors on. And here, the description of the property is especially of note because customs will identify the entry line item number and the merchandise that it is detaining. And customs might put a hold on the entire entry in their system, but the merchandise that is to be detained might only be one line item of several that the entry contains. So it's important to always review the detention notice in its entirety to understand better what exactly is being detained as opposed to just assuming that the entire entry is being detained. And this is a continuation sheet that the officer will typically provide to explain to the importer its options at this stage and what documentation or information should be submitted to customs for admissibility of that merchandise if you were to seek release. And here I've included a redacted detention notice to show what is typically asked by customs for a detained shipment. And this is for a shipment of hypothetically detained cotton merchandise to show that the merchandise is not subject to the Xinjiang cotton WRO. And as Ms. Randazzo mentioned before, the notice will look different depending on what WRO that it relates to. But on this second sheet, virtually all WROs, Customs is looking for the list of all suppliers in the supply chain and mapping out of at all tiers from dirt to shirt who exactly was involved in the manufacture of the goods. And I will walk through later the particular documentation that Customs is looking for to cover the supply chain. But this is a good indicator of the mapping that Customs is looking for, as well as the traceability that Customs is looking for. So if your merchandise is detained, you have three options. You can either export the goods where into a country where the goods are admissible. So that could be the originating country where the goods came from. It could be another market that might accept the goods if that was hypothetically Australia, for instance. But the re-export should be facilitated by your broker to get the goods out of that port. The second option would be to abandon the goods. And in that case, an importer essentially walks away from the merchandise and also the value of the merchandise. So they're no longer seeking claim of custody or title to the merchandise if they choose to abandon it. And the third option, which is of course ideal, is to seek release of that merchandise. And I do want to note at this point that distinction I made earlier that seizures are treated differently than detentions. The option to re-export is available for WRO, but if it was to be seized, it cannot simply be re-exported. So that is an option that only if your merchandise is covered by a WRO, you should heavily be considering. And if you are seeking release of the merchandise, you should be cognizant of the demurrage charges because those will quickly accrue while the merchandise is detained. And we've seen importers who are caught off guard by the tens of thousands of dollars that they may have to pay in demurrage fees while they are seeking release of the merchandise. So it would be best to move the cargo to a less expensive bonded warehouse if available. And also, I had noted before that Customs will note on the detention notice the particular line item or line items that are being detained. And if you, for instance, were to have an entry with 10 line items and only 2 line items were covered by the detention and are to be part of this WRO response, you'll want to manipulate the cargo for those 8 other line items on that entry to clear that part of the shipment and have that released right away, because it's an option for your broker to file form 3499 and have segregation of the detained merchandise from the merchandise that Customs is willing to release at that time, so that you can get at the very least the 8 line items of goods as soon as possible. And if you are to obtain release, as Ms. Randazzo stated earlier, you should immediately seek from the foreign seller of the merchandise a certificate of origin as prescribed under 19 CFR 1243. And in addition to that, we will want to procure any documentation that supports the supply chain being free and clear of forced labor and not subject to the WRO. And once that documentation is submitted to Customs, the 2 options that you will have are release of that merchandise if customs does find that the evidence is adequate and sufficient to release the goods, or you will receive an exclusion letter from customs that states the goods are formally excluded from entry into the United States. And as Ms. Randazzo had mentioned before, the date of that exclusion notice triggers your right to protest the exclusion of the merchandise from entry. So as Ms. Randazzo had said, in some cases, because there is an extensive document package that Customs is reviewing, it's possible that the review does extend past that 3-month period of review that importers have. But when receiving that exclusion notice, it should be logged, it should be calendared, because that will trigger your right to protest. And I apologize. And I did want to walk through the timeline in a bit more detail, because it is extremely important that the dates of interest are made aware to your sourcing team, your logistics provider, your broker, because that is what truly triggers your rights to the merchandise and certain processes that you can be afforded by. So once the detention notice is issued, an importer has 3 months from the date of importation to either export, abandon, or contend the detention. And I want to emphasize again that it's the date of importation. It is not the date of entry, and it is not the date of the detention notice. It is 3 months from date of importation for an importer to decide what they want to do with that cargo. And if no statement is given to customs, those goods are deemed abandoned. And if information is provided to customs, but there wasn't enough time to review and customs hasn't had enough time to issue their decision, the goods will be deemed excluded, and you'll receive that exclusion letter at that time. But once that exclusion letter is issued, by operation of law under this timeline, or by receipt of that exclusion letter, an importer can file protest. And what we have found is the supporting evidence that's filed in the protest is typically the same as what importers would have gathered for that initial WRO response contending the detention. And that's because importers are trying to put together the best admissibility package based upon the supporting documentation that we know customs is looking for as adequate evidence that the shipment can be released. And if an exclusionary protest is filed, we would recommend that in the ACE portal, or however the protest is being filed, that you select that it's an exclusionary protest, because comparatively to a protest on classification or valuation, the time frame in which customs will decide on that protest is much shorter. Customs has 30 days from the filing of that exclusionary protest to make their decision. So it's important to select exclusionary as the type of protest you're filing at the time of filing. And it's also important to make that filing known to the customs official that you've been communicating with, whether that is the and it should be both, but whether that be the customs officer that issued the initial detention notice, or if you are a CTPAT member, your national account manager. We have found that the national account manager has been incredibly helpful in coordinating this filing and communication among their colleagues. So you will want to notify customs that you did file this exclusionary protest, because they will not otherwise receive an automatic flag or notification through their inbox. And if they don't know that the exclusionary protest has been filed, they may not know to review it and decide upon it. And if an exclusionary protest decision is not issued within 30 days, that protest is deemed denied. So similar to the triggering of a right to file a protest once an exclusion letter is issued, once that protest denial is received, that protestant can go to court. But it is, again, critical that the importer communicates with customs throughout the whole process, but really once the merchandise has been excluded, because the time frame in which the cargo would need to be re-exported or abandoned is protected by a protest filing, but it's the onus is really on the importer to let customs know that a protest has been filed. And as Therese mentioned before, customs wants to know who all of the suppliers are in your supply chain beyond tier 1. And it's important that importers not only have their arms wrapped around the universe of suppliers in their supply chain, but also have it mapped out so that it's very clear at what stage of production and manufacture the merchandise was at that factory. So in this diagram here, I would recommend that, if hypothetically you were to have a cotton t-shirt, let's say, detained, then letter A would be that finished goods manufacturer and or seller, depending on, who the middlemen are. But I also realized I have these snazzy fly-in words. And so the supply chain mapping is really going to explain to customs who manufactured the merchandise, what was manufactured, what stage of the manufacture you're in, and then where that stage of manufacture took place. So in our scenario, if you have a finished cotton t-shirt, you'll want to very clearly map out that the finished garment manufacturer, letter A, was the company at this particular address, and have their name in English for translation purposes for customs. And also it's helpful to know in the native language what the name of that supplier is, because as documents are being tied together in the ordinary course of business, they're not necessarily being issued in English. So you'll want to make sure that you can tie in the English translation to that native language name of the factory that might be listed on the original documentation. And then from there, you'll want to know the different, perhaps, fabric manufacturer as B1, or the trim supplier, letter B here. And then from there, the seller to that tier 2. So if you have a yarn supplier of polyester yarn, for instance, as C1, and a cotton yarn supplier as C2, you'll want to have this mapped out in a very clear fashion so that you can illustrate exactly what companies were involved at what stages in the supply chain in the manufacture of your garments. And as Ms. Randazzo mentioned, it is incredibly important. It is necessary for the release of merchandise if it's, God forbid, detained, that you have the right traceable records in place to show and prove that there was no forced labor in your supply chain and that your merchandise does not fall under the WRO or finding. So we would recommend that you have in place the record keeping requirements for the transactional records at each tier in the process, that being the commercial documentation of the order that was initially placed and the invoice to fulfill that order, as well as proof of payment between the parties. We also recommend to have the transportation records at each tier, whether that cotton was trucked to another facility in that same region, or whether there was a bill of lading showing that palm fruit or that crude oil moving from country A to country B. You want to have evidence of the movement of those materials and those products to show at each stage in the supply chain the movement of that particular material of interest. And in addition, we would recommend production records to prove that that fabric maker who was involved in selling that fabric to the finished garment manufacturer was in fact the actual facility and at that address where the fabric was made. We, of course, also recommend that every importer have a signed affidavit or some type of statement from the manufacturer that attests to the fact that the particular material or product was made at that facility, at that address, in that country, speaks to the processing that was undertaken at that facility, and to also note that there was no forced labor at each tier that they were involved in, and that there was no commingling with material from that facility or entity that the WRO or finding might be on. And we would recommend these affidavits or signed statements at every tier of manufacturer. And it is not enough to have these records, but it's also important that these records connect from one to another. So I have an image up that shows how you would want to connect the bale number of cotton, because as Ms. Randazzo said, for the Xinjiang cotton WRO, customs expects you to trace back to that bale of cotton. So you should have the bale number of that cotton on all of the transactional records that are being kept, so that you can show the trail throughout its connection and show that, yes, we can prove that this bale of cotton went into this, roll of yarn that went into this roll of fabric, and so forth. And because there is, so much risk at stake in having even a drop of that tainted material in the production, and there is no de minimis requirement, we would recommend that you also have controls in place to prevent commingling of the materials during production, so that you can not only show that this particular cotton from this particular cotton ginner went into your product, but that there was no other cotton commingled in that production. And although costly, we would also suggest that you consider scientific testing of the material. And there are DNA tests that can be done to show where the origin is of that particular material, and it's compelling evidence to show that that material did not come from the WRO related region or facility. But what do you do if you have multiple outstanding orders from the seller who you just had a recent detention for? As Ms. Randazzo mentioned, customs will be treating every shipment separately. So it may speed up the document procurement process if you have received multiple detention notices on the same goods from the same supplier, because there should be overlap then potentially of some of that documentation, whether those be, the bulk order of ginned cotton or crude oil, let's say, that was sent to your tier 2 supplier, that might stay the same. But it's important that you undergo the same steps in putting together that admissibility package to show customs that for that particular entry, for that particular detained merchandise, this is the evidence that you have to show that the merchandise was not made with forced labor. So it does sound duplicative, but it is required by customs. And importers should also be aware that WROs and findings are a very drastic, it must feel drastic, and overwhelming way to learn of a potential issue in your supply chain. But there are other tools that customs can use to enforce its forced labor laws. And those include a customs request for information. So customs can send out a CF-28 or a CF-29 to importers to ask for more information about their supply chain. Customs can undergo a focused forced labor audit of an importer to make sure that its supply chain controls are in place, and customs will often select a sample entry or multiple entries through which this paper trail is tested. And lastly, it is important to point out that not only can customs go after importers through these tools and potentially a civil investigation if it came to that, but customs could initiate a criminal investigation in certain situations. So the hot topic currently is WROs and findings, because that seems to be most imminent and disruptive of a supply chain in the immediate stage. But there are other tools that importers should prepare for to make sure that they are in compliance with customs. And at the end of this presentation, if you have any questions, please send them over to Paula and I would be happy to answer them.
Great, Amanda, thanks so much. I do actually have questions. We've got a few that have come through. So first one, if the goods are abandoned, who is responsible for costs incurred by CBP in the disposition? Do you have an answer to that? Do you know that answer to that question?
So that's a great question. And to date, when my clients have abandoned the merchandise, they have walked away from the merchandise. And so to my knowledge, there have not been demurrage charges issued for the abandoned goods. And David, I'm sure you've had experience too. I saw your face on the screen, happy to share the answer for this.
So what happens with these goods, because they are excluded, they will go to general order, and under general order, there is the possibility that the consignee could be responsible for customs disposition. If it gets sold out of general order for export, for example, which I don't think they would do with convict labor goods or goods that are suspected of convict labor, they could cover those costs. But possibility. Collection on that, we have, like you said, I haven't seen collection by customs of their costs, but it's something that is a worry.
Sure. We have another question too. Will CBP let the public know that a particular importer or exporter's goods have been excluded?
No, that should be business confidential information.
And then also we had a question about scientific testing. Basically, maybe a little bit more. Can you elaborate, maybe just briefly, because I know we want David to do his presentation, but basically a little bit more about scientific testing, and has customs accepted any of that, the DNA or isotope testing of cotton that you're aware of?
Yes, and Ms. Randazzo, I'm not sure if she's on, but she can also speak to this. Scientific testing has, in my experience, been accepted with the other documentation. So, it would not be enough to submit an Oratane test that shows the origin of the cotton based on that laboratory finding comes from, let's say, Bangladesh and not Xinjiang. But at the same time, customs isn't looking just to that scientific testing. It's also looking to the overall admissibility documentation that is required to show there is no forced labor in the manufacture of that merchandise and that the origin of that merchandise comes from elsewhere.
Okay, we also had a question about the bail number, a requirement in documentation. And I think that Therese also talked about the bail number as well.
Yes, it seems to be extremely difficult at this stage for importers to gather the commercial documentation that shows the cotton bail number on the invoice to that yarn supplier, for instance, but that is what customs is looking at, for it to be on the commercial documentation. And I do expect that over time, this is new for everyone. And so when you have a crop of cotton from 2018 and the WRO wasn't in place until really, late 2020, early 2021, that Ginner did not know at the time in 2018 to include necessarily the bail number on the documents. But if moving forward, that could become a requirement, I would strongly suggest that.
Right. And then I think we have one last question. It has to do with the 3-month period when the WRO is over, the importer must export. The question is, what regulation does this then shift to that explains the process and timeframes the importer must follow? And then also with the WRO, is product destruction is not an option, or is that correct or is that incorrect?
Sure. So for the first question of, what regulations govern it, the regulations speak to the just general re-exportation, but your broker should be familiar with re-export of the goods out of the US, and they should be doing that very, very quickly just for cost purposes. But to my knowledge, there's nothing in the regulation that says it needs to be re-exported by this certain period of time. It could sit there and you would incur all of the costs. And then the second question, Paula, could you repeat that?
Yeah, they asked if product destruction is an option versus export.
Yes, certainly. And I've done this with several importers. It's also a PR concern for companies. They don't want their merchandise to be re-exported, and it's known that their brand might be associated with this factory. So you could certainly destroy the merchandise, but it is also an expensive proposition. You can, in many cases, get refunded through drawback for some of the duties paid. But yes, to answer your question, destruction is an option.
Great, thanks. I just have one comment on the export piece too, just from my experience is that you should make it clear with your suppliers, if goods have to be exported, that they will bear the cost, because I went through this with a client and the supplier did not want to pay. And I think we all know with transportation costs right now, it can become very cost prohibitive to try to get those goods exported. I know that there's another question about best practices. But as far as admissibility packets, but I would like to hold off on tomorrow because I think we're going to cover that in a lot more detail. And I'd like David to get started on his presentation. So really tomorrow is kind of more of a, round table, best practices, things like that. So I think that should answer the question on that and, with plenty of time. So thanks, Amanda, so much for your great presentation. And David, if you'd like to pick up, that would be great.
Great, thank you. Hi, I'm David Murphy. I'm a partner with Grunfeld Desiderio. And, I'm very happy that I've been asked to join this. I hope everybody can see my screen at this point. If you're not, please let me know. So we're going to talk about the Uyghur forced labor statute that has been adopted, which Ms. Randazzo went through quite a bit. And then we're going to talk about some of the various WROs that are out there. So as Ms. Randazzo stated, on December 23rd, the Uyghur Forced Labor Prevention Act was adopted. This is not the first law on this issue. There was an act, a policy act back in 2020, which started this whole process. So, there's other things that the government can do on this, but this really is what's going to affect the trade operations more than anything else. So it went into effect on December 23rd, and it had various timelines for various options that, must be, various things that must be conducted. The first of which is the idea that they solicit comments from the public on how to implement this act. And we'll talk what the act requires them to implement. So as of tomorrow, comments are due on how customs should come up with, well, customs and the government as a whole should come up with a plan on how to prevent the importation of goods made with forced labor. The comments, I know various trade groups are doing it, individual groups are doing it. Customs will take those, working with COAC and with other stakeholders in this, to come up with their plan, as we'll see. Sometime the Forced Labor Enforcement Task Force, which is a multi-agency group, is going to be holding a public hearing, at which time individuals can respond to perhaps comments that are publicly out there, and also let this Forced Labor Enforcement Task Force know what they feel should be included in the process. So on June 21, there will be the imposition of this rebuttable presumption that goods produced in the XUAR region and certain entities are inadmissible. And we'll come back to the entities in a moment. The statute provides that 180 days after the enactment that this presumption comes in. So if we have goods that are from this region, they are inadmissible under this presumption. Now, it is rebuttable. And if you can show that you have fully complied with the guidance provided by the CBP, which is what we're going to, so that sort of due diligence standard, and you have clear and convincing evidence that the goods were not produced or manufactured in whole or in part by forced labor, customs could release it. Now, backing up for a moment, one of the things, when this law was drafted and passed, while it does target the XUAR region, I hate acronyms. The statute itself says that they have to come up with a policy for enforcement of forced labor in the People's Republic of China, including the GUAR region and made by certain ethnic groups. But basically, it could be anywhere in China. So while we've been focusing on this one region, if customs gets evidence presented to them of other areas in China, they can include that in their enforcement plan, as we'll see. The presumption goes into place. You have to come back with clear and convincing evidence. And Amanda addressed this somewhat in the way they're handling this under the WROs in general. But this clear and convincing evidence standard, in addition to the detail that you need to supply, in addition, you've got to ratchet it up in the sense that the evidence has to be substantially more than just probable that the goods are not made with forced labor, but it's highly probable that the goods are not made with forced labor. It's not, you don't have to prove the absolute, but it's pretty close. Customs has looked at this in connection with North Korean forced labor back in 2001. And in that situation, the importer couldn't meet that very high standard. Even under the 12.43 standard that are for the general WROs, is probable probative evidence to establish that the imported cotton products were not produced in part by forced labor is it's a very, very difficult standard to meet. And when you ratchet up to clear and convincing, it's going to be even worse. Okay. The only court case I have seen on anything that might give us some insight how this is going to work out is pending in the CIT, but from what I understand, it's now being subject to some sort of settlement negotiations, and the goods are going to be moving out. I don't know whether it's going to move forward, but they're involving palm oil, again under the 12.39 standard, despite having apparently substantial evidence, according to the complaint in that, they were unable to meet customs standard. So when looking at our documentation, Amanda talked about tying things together. It's not only tying them together, but to show that they are highly probable to show that the goods are not made with forced labor, which is a very, very, very difficult standard to meet. Okay. So by June 21, which is also the same day that the rebuttable presumption comes into place, Customs is supposed to submit their enforcement strategy and also provide guidance to importers on what their due diligence requirements are on supply chain chasing and the evidentiary elements to show that the goods were not made with any forced labor. In that, they will be listing entities, production facilities, exporters, which they have evidence about. Okay. They will also be identifying products. Now, the priority products are what we've seen already: tomatoes, cotton, polysilicon, which is, when that really starts hitting, is going to be interesting. But like I said, the statute talks, while it focuses on the GUAR region, it could expand out to other areas of production in China if they have evidence to do so. Same thing with the products and the entities and things like that. Now, harkening back to the question about whether the importers' names get released. Well, here they're not naming importers. They're talking about Chinese entities, Chinese production facilities. And you would imagine the exporters are going to be located in China or Hong Kong or But that could be also, there's a possibility that, if you're listed as the exporter on documentation, whether or not that information is going to be made public, that is a problem. Okay. So, once we get this strategy, it's going to outline what are the due diligence standards. So while we have all talked about what we're doing now in order to comply with the WROs, that is going to change. It could change based upon what customs puts forward and how much detail it gives. Ms. Randazzo really couldn't speak to that at this point because it is, what they call pre-decisional. It can't be. But they are looking to COAC into other stakeholders to provide them with guidance on what to put into this enforcement strategy and to put into these due diligence standards. Look, at some point, somebody's going to challenge whatever customs does in court. So they are going to try to be as reasonable as they see as possible. The industry may not see it that way. Will this be an impossible standard? Who knows? We're all sort of sitting here with bated breath trying to figure out exactly what that's going to be. But, you can imagine it's going to be at least what we have seen already in customs requirements. There are 1 or 2 rulings out there about exclusions under the WROs and what customs has looked at, but doesn't give us sort of a detailed roadmap, which it looks like in there, at least the way the statute is written, they will be giving us certain guidance, which hopefully will be a stronger roadmap of what due diligence, tracing, and evidentiary requirements we need to meet in order to get goods released. Okay. So that's all the fun stuff on the UR statute. We've talked about a couple of different WROs. Ms. Randazzo ran through a long list. On Customs website, they have this great graphic which shows where the various WROs have been issued. We've, especially those in the apparel industry have been worried about China. Those in the food products industry have been worried about Malaysia. But there, the fishing industry, there's been a couple of different fishing vessel issues. But there are a number of them that are out there. Some of these are way old, but some of these, as Ms. Randazzo mentioned, since the last 2 years, there's been a big uptick in the activity on this. So the active WROs for China, which seems to be the target for this, and that is a function of 2 things. One is where customs gets its information from, and perhaps just the state of affairs, where they're getting their information from. Non-government agents, organizations that are involved in the labor area regularly, create reports, which Ms. Randazzo showed you some of those websites where you can look at some of those things. The State Department looks at these things. And it's based upon that information that gets fed to customs that they have been coming back with these WROs. It's, when we're talking about hair products, it's a little bit more, limited industries. But when we start talking about garments, apparel, cotton, polysilicon, there's going to, this is being, expanding to the product groups and the number of importers who are going to be affected. While we're looking at this, one of the things you want to be careful with is who is the WRO issued against. Some are against individual companies. Some are, will mention several companies, subordinates, affiliates. We'll see one in Malaysia that talks about joint ventures. So you have to do your due diligence. You know, even though a WRO has come out and we're not one of the named bright line named suppliers, you could still be covered by it. Now, they don't release a detailed announcement on the WRO, but generally the heading will tell us whether or not there are subordinates, affiliates, and joint ventures involved in it. You know, disposable gloves out of Malaysia was, you know, one of the earlier ones that we saw. You know, there's a number of those that have popped up. Palm oil more recently out of Malaysia. Malaysia is another primary target right now. Again, based upon, you know, NGO reports and government reports about the labor conditions in the country. So, you know, they've seen an expansion to those. Turkmenistan going back, these fishing vessels, which are one of the, you know, become an issue. It's the two palm oil ones here on this slide that mentions subsidiaries and joint ventures. Well, how do I know whether my company is a subsidiary of this? Well, it's your responsibility. You know, reaching out to them, getting verification of that. Hopefully they'll be truthful. There are databases and companies that will do corporate research to determine whether or not a specific company has an ownership interest in another. You know, again, this subsidiary idea, is it wholly owned? Is it partially owned? You know, OFAC uses, you know, a 50% control level. There's no sort of statement of that here. So that could cause a problem. Then joint ventures. Well, if it's a public joint venture, you know, names the company, that's, you know, easy to identify. But if it's not, if it's, you know, more behind the scenes, you know, two companies have gotten together, formed a third company as a joint venture that has a totally different name. Again, it's difficult to know. So you want, again, are going to have to look at sort of corporate research in order to see whether or not any of those joint ventures are involved. You know, it becomes almost a guessing game with a lot of these. You know, whether or not you're going to be covered by it, and you may not know until the last minute. Your goods are here, and you know, all of a sudden, customs is stopping you, and you are, you know, caught in the middle of it. You know, there are, like I said, older WROs out there. The ones in Mexico, as we saw on that map, they go back to the 1950s. There are others in China going back to the early 90s. So, you know, those, you know, suppliers have long left. So those are less of a worry. It's these broader ones that start, like the WROs, Suar, cotton, tomatoes, and polysilicon, where it's targeting the product rather than individual company, that are going to be very sweeping. I know as it relates to the palm oil, there's been rumors in the industry that customs is looking to expand it beyond the two companies that were mentioned there, and their subsidiaries and joint ventures and things like that. I guess the issue is, you know, when do they have sufficient evidence to do that, and will they do that? Now, go the wrong way. There we go. As to findings, there haven't been a lot of findings out there. You know, one finding from you know, certain goods, you know, some are inactive, but the active findings out there, and actually it's very interesting on the Sim Darby finding, customs announced the other day of a seizure under one of those findings in the port of Baltimore. Apparently palm oil products, palmitic acid, came into the port of Baltimore. The importer, apparently, according to customs press release, decided not to contest it. It sat in the port. I guess over the 90-day period, it was excluded, but ultimately got seized once the finding came out, and Customs just recently announced that seizure. You know, another finding is on stevia, which, you know, from Mongolia. You know, that set the industry on Twitter because there was such a heavy supply coming out of that area to scramble for other sources of supply and to try to rehabilitate, you know, the entities there. You know, I'm not, you know, privy to what's going on behind the scenes on that, but, you know, they're apparently Malaysia and Indonesia, other possible targets for WROs or alternative sources. So whenever you see a product that has a WRO finding or just a WRO against it, you have to worry about the industry. Is this an industry-wide methodology of using forced labor, or is it just those specific entities? You know, trying to keep ahead of this, like this Randazzo mentioned, there are a number of websites that are out there that you know, talk about forced labor conditions in various countries, and the findings and the like are on Customs website. But one of the things you want to make sure is that, you know, you do your due diligence on whatever products you're dealing with. You know, what we've come is a new level as we're seeing the expansion of this. You know, the amendment of the statute for forced labor that removed what is called the consumptive demand requirement has, you know, instigated this current flurry of this, but it's something that is not going to go away. It is something that NGOs, these non-government organizations that are targeting forced labor and other conditions in various countries have found to be an effective tool. So we're going to see a lot more of these down the road, is what I anticipate. You know, it's just a matter of time. I think a lot of them, a lot of those NGOs and the like who have something in their pocket, perhaps to bring to Customs, are waiting to see what they're doing with this UR legislation to, you know, see if there's something they can use on that to bolster their situation. But, you know, like I said, I think we have a lot more coming down the road. Okay, so at this point, I guess we are going to go to questions, right?
Yes, we are going to go to questions. So I have a question here, and I don't know if it's specifically for you, David, but either, you know, any of you can hop in on this and share your expertise. This question was ahead of June 21st. Are there any educated approaches an importer can take to proactively create an expanded entity list to screen against? For example, is there an updated map of pairing program participants maintained outside of the 2020 issuance of the Xinjiang Supply Chain Business Advisory? Does anyone have any comments on that?
Well, there have been entities that have been named for export purposes.
Right.
But I don't believe for import purposes anybody's, you know, sort of circulated a list at this point.
Yeah.
Amanda?
Yeah, you know, we might expect that when the Secretary of State issues their report later this month, March 23rd, there might be lists in there that could provide additional guidance. But I absolutely agree with David.
And I do believe that once, I mean, one of the requirements under the UFLPA is for the government to publish a list. So that would, you know, certainly be something that, you know, for reasonable care purposes, an importer would need to, you know, be aware of that and not basically say, well, I had no idea, because again, they're coming out and publishing that list. We do have another question. would it be good practice to require suppliers to provide a declaration on the import documents, which would declare no forced labor was used in the supply chain? Thoughts on that?
Well, it's nice window dressing.
Yeah.
It is, there's an older court case where reliance on the supplier alone is not reasonable care. So while it might assuage people inside the company that things are okay, without doing some digging on your own, the statement doesn't get you anywhere. Now, take my customs lawyer hat off and talk about it as a general lawyer. If you get a statement like that, you can turn around and it turns out there is forced labor and you might have some sort of claim against your vendor, but that's at the end of the day, that's the least of your worries.
Yep.
Right. It certainly is good practice, but to David's point, it could be more protection under contract law than, showing that you're exercising reasonable care.
I actually had a couple of questions too, and I don't know if anyone has these answers, but I guess just for practical purposes, do we have any idea percentage-wise of goods shipments that are detained? What is the likelihood of detained shipments actually being released? Any thoughts on that?
That would be such a depressing note to end on.
Well, let's hope we don't end on that. But
I'll find something else to ask about that's not so depressing.
What we have seen is because the importer has to prove the negative to a large extent, the chances of getting goods released are very, very low. Even to the point, one of my partners called it, have to get the cotton picking records. Where was the, even though we were talking about bales of cotton, if that was sold to a cotton wholesaler who commingled, you got to get the cotton picking records. Where was that cotton picked from? Where did it come from? So it becomes almost impossible if you think about it from a purely narrow viewpoint of proving the negative.
Right.
How are you going to do it? So that's why, I'd say the majority of the cases I've handled under this, the importer said, send it back. I'm not going to deal with it.
So quick follow-up, and I don't know if there is a correct answer to the question, but thoughts on whether or not an importer chooses to just export the goods back. Any thoughts? Does this become a red flag, or is it just hey, it was a business decision on the part of the importer? We don't, we can't do this. We don't have the resources. We can't continue to pay demurrage. Do you guys have any thoughts on whether or not CBP would, take that as, some sort of red flag that the importer has no controls over forced labor in the supply chain?
In conferences that I've had with customs, they have explicitly said it is not a red mark on your record.
Great. See, now we're ending on a much higher.
But
there you go.
That being said, just like with marking violations, that may not have been the problem of the importer.
Right.
You keep hitting the same wall over and over again, you're going to leave a blood mark. And customs is going to probably at some point, if you had a repeat offender, let's say, it's not an offense, but a repeat offender, they're going to have a problem with you.
Right. Oh, absolutely. Agree 100%. If there's a repeat, yes. But
Yeah,
for just your one-time person bringing it in and just saying, I can't do this, and and that's the end of it. You hope that perhaps it's not a red flag on their record. Erika, go ahead. I know you wanted to join in.
No, I agree with what both Amanda and David said. I would say just from a practicality of the supply chain, it also, at a minimum, might raise a question of customs, especially if it happens more than one time, like how well do you know your supply chain? Because what they will be looking for is like, how, let's say a transit time is 45 days average wherever you are. How is that you suddenly just have to return it? I mean, the practicality becomes even more important of some of the stuff that we're going to talk tomorrow, I think, of challenges and best practices.
Right, right, definitely. I do have one last question. I think we can maybe try to touch on this. Do the lawyers on the panel feel there is an issue between the A1A record keeping list, which has been what Customs has traditionally considered record keeping documents or documents in normal course of business, versus what seems to be an expanded definition described by CBP today? So again, I think, the question is that, some of these documents obviously are going to be challenging for an importer to obtain. So thoughts, anybody else?
Well, the A1A list is what you can get penalized for not having records.
Right.
Ms. Randazzo mentioned records kept in the ordinary course of business. Importers don't keep these records in the ordinary course of business. They're going to have to go out and get them.
Right.
And interestingly, once the enforcement strategy comes out, this due diligence standard comes out, will there be mandated documents? Again, I don't think they'll get added to the A1A list because, again, that triggers a penalty. But while they may not officially be added, it essentially becomes, a must-do if you're going to be doing business. In the A1A list, it's also kind of fuzzy. It talks about supporting documents for some of your declarations.
Right.
I don't think, well, if you're going to be giving a certification under 12 point, was it 40? Yeah, there it is. Yep. 12.43 is on this A1A list.
It's on the A1A, yes, we thought.
So, it doesn't mention supporting records for that, which some of the other ones do. But my feeling is, you can't have a certificate of origin executed by an importer without the supporting records.
Right.
So, yeah, if we're going to be issuing those certificates, you better have those records in your possession.
Right. Great. Okay, so I want to thank my panelists here for a great presentation, and also I know Therese is off the call, but we appreciate her coming in and giving an overview on the customs side. We look forward to tomorrow. I think we will be providing a lot of very helpful information to everyone, best practices, and really kind of walking through a supply chain review and what you need to consider. And I think after what everyone heard this afternoon, I think the importance and significance of knowing your supply chain and how it can vary depending on your product. And that's what we're going to focus on tomorrow. So certainly have your questions ready for us. And again, I want to thank everybody, and we'll pick up again tomorrow afternoon at 2:00. One comment on the CCS points. I know if people had reached out for CCS points, they are pending. So you will be getting them, but they are pending right now. So I think that's all I have for today. And I guess we will see everyone tomorrow afternoon. Thanks again.
Thank you very much.
Have a good day.
Bye-bye.
Thanks.
Bye-bye.